Welcome to the Catalyst Podcast. I'm your host, Charles Epstein. Joining me today is John Hyman, a nationally recognized management side labor and employment lawyer who provides businesses with proactive solutions to solve their workforce problems and reactive solutions when they find themselves litigating against employees. John is shareholder director with Wickens Herzer Panza, where he is employment and labor practice chair, and perhaps even more importantly, craft beer practice chair. If we have time,
got to do what you love.
Got to do what you love, man. Absolutely. Speaking of, he's also an author, speaker, blogger, and again, perhaps most importantly, the co-host of the Nora and Dad Show podcast. Nora, of course, is his daughter, his college-age daughter, going into her second year. I've been following Nora's trajectory very closely, John. I met John a number of years ago when I was the co-host of the World at Work podcast, and he has since become my go-to, anything having to do with employment law. Today, John is joining me to talk about the case this week when a Los Angeles jury delivered a historic verdict against Meta and YouTube, marking the first time social media giants have been held legally liable for the addictive nature of their platforms. It's a fascinating case, and you are the man. You're the first person I thought of when this came over the transom. Thank you for making yourself available. Before we get into it, and obviously you're joining us, obvious to me, because we've spoken a number of times from your HQ in Cleveland. Before we get into it, the podcast you do with your daughter, how many years have you been doing this? A couple of years now?
We've been doing it for 4 years.
4 years?
Yeah, we have 60-some episodes in the can. So, yeah, it's on a more or less every other week cadence during the school year. We tend to take breaks and the summers off. It's been, I think the coolest thing about it is, we talk all the time anyway, but then it's a bi-weekly, really kind of in-depth conversation about what's going on in our lives. But I think at some point, I'm 53, at some point I'll no longer be around on this planet, and it's going to give her an amazing record of kind of me and our relationship. So it's been a really, really, really rewarding thing to do with her, and it's fun. So it's great, and the two of you have some real shared interests, particularly in music. We're both girl dads. When my daughter was about to go to college, I said to her, Kayla, what's going to happen? You're going to come home in 2 weeks and you're going to go to me, Dad, this guy Dylan that you like so much, he's not bad. And she said, I don't think that's going to happen, Dad. So that was our running joke for those 4 years. Dylan, no, Dad, hasn't happened yet. So you're a very lucky man that at least you could, among other things, you can talk about that. So I'm very jealous of that. So, John, this case, just to give some backdrop, on March 25th, the case Kaylee GM versus Meta and Google, the plaintiff, 20-year-old Kaylee GM, alleged that the companies intentionally designed their apps to be addictive, causing her to develop severe mental health issues, including anxiety, body dysmorphia, and suicidal ideation, starting from age 6. So if you would, walk us through the arguments on both sides of this. Yeah. So, you're right. It was a fascinating case before the verdict. It became even more fascinating now after the jury handed down its $6 million verdict. From the plaintiff side, the plaintiff essentially argued that Meta and Google defectively designed their platforms by making them addictive, and then failed to warn their users of the addictive nature of their social media platforms. That they essentially built compulsive systems that were sticky, systems that kept you on and kept you coming back and allowed children and teens to access the platforms, knowing that those systems could then cause psychological harm, and then fail to put safeguards in place or warnings in place, either to keep children and teens off the platform or warn them about the addictive nature of the platform. And that this caused
to this particular plaintiff caused significant emotional distress, psychological harm, etc. Meta and Google on their side argued, they essentially argued causation. They said, look, youth/teen mental health is a very complex issue, and it's impossible to pin any one factor to say that that was the but for and proximate cause, that it was the reason why this individual, this plaintiff, suffered the harm that she proved to the jury that she had suffered. They also pointed to some pre-existing conditions she had, and said, this is your fault, or someone else's fault, or your fault, but not our fault. And then also tried to show that heavy use of the platform did not, could not and did not legally cause the injuries, the injuries that happened here. Those were the arguments that were made. Obviously, given the fact that the plaintiff won this substantial verdict, the jury felt that the plaintiff had the much better side of those arguments.
Yeah, for sure. Obviously, the plaintiff is not the first person who's had this experience using social media. We know that by design, they tend to be addictive, for lack of a better word. Why did this all of a sudden come to this point? Why was this case tried? Was anybody behind it? Is there any group behind this?
That's a good question that I don't know the answer to that question. In terms of why this was the case that was tried, and there are, over 1,000 other similar cases that are pending around the country. It's this particular court, this is the case that just got to trial first. And as a result, it's the one that made the headlines. We can talk about kind of what its impact is. I think the media, as mass media often does, in this day of, they have their own interest in getting people to stay on their platforms. And so, they have blown this up to be like the end of social media and, and it is a significant case, but we can get in and talk about kind of why it might not be as significant as the pundits and talking heads on TV might want you to think it is.
Oh, I'd love to hear what you think about that. But yeah, that's not the most interesting thing. It's just sort of an interesting element, how all of a sudden, or why all of a sudden did this become a case? Why was this tried when we know that, this is not an isolated instance?
And look, most cases don't get tried. I'm a litigator. 99% plus of cases never go to trial. Now, if you're Facebook or you're Google and you write a check and settle this case, and then that makes headlines, and then, case to settle and dismissed for an undisclosed amount, then that might encourage other people, and they must have felt they had a decent enough chance to win the case, or they wouldn't have tried it. But the fact that this plaintiff tried it and won this case certainly is not going to dissuade other people trying to do the same. So.
No, for sure. So now that this jury has ruled that these platforms are defective by design to cause addiction, could an employer be held liable if they require employees to use these platforms? Is that a potential problem?
In theory, yes. And so, for example, the DSM-5, that's the diagnostic manual that psychologists use, the latest diagnostic manual of kind of mental health disorders. At least in a draft version of it, had internet addiction as a mental health disorder or mental health disability. And so there are lots of theories out there on, the internet as addiction, and the ADA, the Americans with Disabilities Act, covers addiction as a protected disability. Drug abuse is a protected disability. Alcohol abuse is a protected disability. Some cases have held that things like sex addiction are a protected disability. And so these things are recognized as protected disabilities. And if, internet use disorder, internet addiction is a recognized psychological disorder, then that becomes a protected disability as well. So in theory, I think the answer to your question is yes. I think in practice, I don't think it's nearly as cut and dry. I don't think that this case, for example, means that employers, even employers of individuals that use social media as part of their jobs, I don't think it means that employers suddenly become like strict guarantors against the psychological effects of workplace technology or technology used in the workplace. I mean, this particular case was about a product design, aimed at minors, not employer supervision of adults. So the kind of the precedential effect, to the extent this case has any precedential effect, the precedential effect of this decision wouldn't reach employers. So I wouldn't describe it like as a ready-made, judge, here's this case and you need to hold my employer liable because I'm the social media manager and now I spend 22 hours a day
Right.
on the internet. It's not that. It's not that. But it does, but rhetorically, it certainly lends to the discussion, and it's certainly not going to dissuade plaintiffs and their attorneys from trying to extend the logic of this case into like either whether it's an OSHA context, right? You have an obligation to provide me a safe place to work, and you did it because you make social media available, or you got me addicted to the internet, and now you have to accommodate, or I'm addicted to the internet, and you have to somehow reasonably accommodate that addiction.
So you can't necessarily extrapolate and extend this to the workplace. In other words, it's not all of
Correct.
a sudden a bigger duty of care burden placed on organizations
No,
vis-a-vis social media
I
use.
don't think it is, and I think a lot of people are going to tell you, and that's why part of the reason why I think the talking heads want to make it sound like, and I recognize the purposes of today, you and I are talking heads as well, as I see your head on the screen.
Yes.
But the CNN, right? The CNN talking
Sure.
heads, right? They want to, they want to say that this is, they want to make this as significant as possible. And the more we talk about it, certainly the more rhetorical momentum this case gains. But I don't think that one jury verdict out of one court in California is going to set a new standard of care. In California as a state, or on the national level. All I think it does is kind of help set the stage for a narrative that digital systems like Facebook, like Instagram, like YouTube, can be engineered and designed in ways that can foreseeably contribute to mental harm. And that to me is not, I mean, we've been talking about this for a few years now.
Right.
And so that to me is not an outlandish or a new thing to say. But I think in terms of whether there is a new standard of care, right, around internet safety, I think it's a couple of steps or more than a couple of steps too far to say that this case creates that standard of care. Now, if we have many, many, many verdicts over a span of several years, across the country, I for plaintiffs in cases like this, we can record a new episode and we can talk about why there is now a standard of care imposed upon social media providers. But we're not there yet. We have a ways to go.
Yeah, sure. It's kind of interesting though. I kind of want to move the conversation to AI because I think there's sort of a continuum. You have digital addiction, which is for the most part apps and social media. AI, I think, is an order of magnitude different, arguably more insidious, because you're now dealing with something, particularly when you're using Gen AI, one of those chatbots. There's this sense of some sentience on the other side. You're engaging with more than just a machine. There is that illusion. And that has been shown, creates dependencies and a form of addiction that can be more pernicious and has led to some very, very dire results. Any
Yeah, I mean,
concerns about that?
yeah, I mean, so for example, you have the case of it's pending where the parents are suing over a chatbot allegedly causing their child to commit suicide, right?
Right.
So I think, to your point, you can make the argument. You are making the argument. I think it's a correct argument that this case, the Meta Google case, the verdicts from yesterday, um, isn't just a case about social media platforms. I think it's a case about what happens when a company designs, as the jury found in this case with intent, a digital product that has the potential to change human behavior.
Yes.
And Gen AI certainly can do that. People are turning to ChatGPT to get, answer questions about all kinds of things. And at least with ChatGPT, one of its greatest shortcomings is it has kind of an unending need to try and please you.
Yes.
to make you feel good about yourself, which could lead to some really bad results if you don't feel good about yourself. And the chat bot feeds into that by reinforcing your bad feelings that already exist because it wants to praise and reinforce. So it thinks it's doing right, but it's having kind of the negative consequence of what it actually intends because it's being overly pleasing. So I think you're right. I think this case does have some potential significant implications, not just for the social media platforms, but maybe even more so for the Gen AI platforms.
Yeah. And particularly so because Facebook and YouTube are not really core business tools, whereas everybody is using Gen AI, and if they're not using it consciously, it's embedded in some of the applications they're using, so it's kind of ubiquitous. So that's sort of that double whammy. So not only does it have some of those behaviors built into it, or at least those, I hesitate to use the word coercive behaviors, but it's in a context where people are relying on it more than they are, obviously Facebook and YouTube. It just seems to me to be a problem that's brewing, and this seems to set that argument or that kind of litigation up.
Yeah, I think you're right. I mean, I think the systems, I could see arguments where people say either this system is designed to create this reinforcement loop where you're hooking me in and then reinforcing the information I'm feeding you. The systems are designed for, over reliance, over dependence, even emotional attachment as these chatbots, particularly the ones that we can talk to and with, evolve. Yeah, so I absolutely can see that argument, and I'm sure lawyers are already spinning, if not drafting complaints, spinning their mental wheels, figuring out, waiting for the right client to come through the door to file that claim.
So given that there may be a new category of problems that emerge from AI, are there going to be more or fewer lawyers in our future, John?
Probably fewer. Probably fewer. But it may be a function of AI making lawyers less necessary, or it may be a function of kind of a self-fulfilling prophecy of I don't want to go to law school because the perception is the job market is narrower for me coming out of law school because AI is doing a lot of things that lawyers used to be able to do. Like I said, I don't think we're ever going to get to the point where I can off put everything to AI, because there still has to be a sense of human judgment that goes into every decision you're making for a client. And I'm not sure in my lifetime, at least, we'll see an AI agent get to the point where it can replace humans in that capacity. But it's getting better. Claude just released their legal plugin that I've been kind of playing around with the last week or so. And it does a lot of things that lawyers do. You give it an agreement and it will pull the agreement apart and tell you all the things it need to improve and give you a red line version of the agreement back. But it still needs a human set of eyes for all the reasons we've already talked about to make sure that the information that you're being given is correct and valid and legitimate and appropriate for that particular situation or for that particular client. And it's going to be a long time, I think, before AI can replace that piece of it. But probably less, I would think.
I think even when the technology is there, it's still going to be an issue of adoption and behavior or familiarity. For instance, I moved a couple of websites
that I have run to an entirely AI-driven platform. I can't find, for the life of me, I can't get a person. And it's actually very good. The technology is very good. It gives me answers in real time, but it's very weird. It's very off-putting. There are times I just want that reassurance.
Yeah.
I mean, have you ever done Waymo? Have you ever done,
I have not driven in a Waymo. My brother has a Tesla and he has the self-driving feature, on his Tesla. And we went to breakfast. He lives in Philly and I was in Philly a couple months ago and we went to breakfast and he summoned his car from the parking lot while we were waiting outside the restaurant. It was raining and he's like, I don't want to walk in the rain. I'll just have the car come and get us. So he went into the app and he hit a couple of, switches or buttons on the app, and the car starts and then we see it back up and drive around and pull right up in front of the restaurant and get us. It was really cool. He said that the self-driving works about 99% of the time. And I'm like, yeah, but it's that 1% that's going to drive you off a bridge.
Yes.
So
yeah, exactly. But that's a lot different. Having your car, it's almost like an automatic valet or a virtual valet.
Yeah.
But it's different. It's a very different thing from getting in the car and driving home or having it drive home.
With no person, at least when he's using the self-driving, like it does require you to you have to look up every minute, I think, in order to keep it active. And there is a certain human, and you can always take over for the car because you're there sitting behind the wheel.
Yeah.
In a Waymo, there's no one there, right?
Right. I think at some point, the technology and behaviors will catch up and people will feel more and more comfortable, with this stuff. We're sort of like right now at a hybrid state. It's sort of like a Schrodinger's cat state, where AI, but not AI.
Yeah. But think how quickly we went from the no AI to this kind of hybrid state, because that was in the span of a couple of years. We've moved to this, right? And now, how long is it going to take to move to where it's like 100% adoption? It's. I mean, I still think AI largely is probably still even in its alpha release. I'm not even sure we've gotten to the beta version of these AI platforms yet. So
yeah, I think it's going to come down to. I mean, we're going to be able to automate almost everything, but it's almost going to come down to a moral choice. Do you want to do business with a company that has all robots or a company that actually employs human beings? It's almost like an Intel inside, people inside kind of a thing. That's going to be an important, metric. What's the head count? I want to do business with a company that has a head count. Anyway, John, I really do appreciate it. As always, you come on and you are, what's the term? Sunlight. It's the best disinfectant.
Oh, that's too kind.
So, yes, thank you for doing this as usual and coming on at a moment's notice. I am sure there are going to be other thorny issues and cases coming down the pike. So keep answering my phone, man.
I will do that. Keep reaching out. I love talking to you. So I'm happy to come on and chat anytime. So
yes, and say hello to your daughter. I gotta say again, I'm incredibly jealous of her. I have a great relationship with my daughter, but not the relationship that you have. And I would give up something. I'm not sure what. I would give up something just so we could listen to the same music.
That's very cool. I appreciate that.
All right, John. Thank you.
Cheers.
Take care. Today, I spoke with John Hyman, a nationally recognized management side labor and employment lawyer who provides businesses with proactive solutions to solve their workforce problems and reactive solutions when they find themselves litigating against employees. John is shareholder director with Wickens, Herza, and Banza. He joined me today from his office and home in Cleveland, Ohio. This is Charles Epstein for the Catalyst Podcast. Thanks for listening.